All right, thank you. Greetings and salutations to everybody joining our May 13th Legal and Policy Committee meeting. It is 6:07 p.m. We are running a little behind schedule because we had an exciting Finance Committee meeting just before this, but we are going to try to be as productive as possible in the time that we have. The first item on our agenda is approval of the previous meeting summary from our April 15th, 2024 meeting. We have our lovely packets that have been provided to us. Thank you again, team, for helping us through the packets. Our agenda is the first item. The meeting minutes is the second item. Are there any questions or comments on our meeting minutes?
Madam Chair, no questions or comments.
Wonderful. Thank you. With that, we can move on. We do have 651 regular meetings and a little bit of background reminder. Member Sykes offered an amendment at our March 18th Legal Committee meeting as follows. Withdrawals or additions to agenda items shall be made no later than 2 days prior to the regular board meeting. There appear to be two options available to us here. And Member Sykes, if you'd like to take the lead on this.
Thank you, Madam Chair. We are still in discussion, and so we will continue to discuss this to come up with a adequate amendment that will be of that the board as well as the administration can agree upon. So I would just ask that we continue to just keep this on the agenda.
Okay, and would you like to keep both versions offered here? And would you like it in the first read or in the roundtable?
Madam Chair, I'm not sure. What would you suggest? I really don't know. The first read, or this is a first read, or roundtable?
Yes. So the legal team provided us two.
Yes.
Possible first reads, and so do we want to keep both of them in the first read?
Yes, we can keep them both so that we can continue the discussion. Thank you, Madam Chair.
All right, thank you. And moving on to discussion of policy 5120, assignment within district. The current version of this, that is the next on the agenda, right? I had something before that. Compensation, yes. I thought there was something before that. Discussion of policy 0147, compensation. And so there was a concern if there was a conflict between the $5,000 statutory maximum and the $3,000 training stipend. I see that a comment and note has been provided here, so please help us.
Sure. So thank you, Dr. Molnar. So my comment here just states that the question was posed at our last board meeting, or I'm sorry, our last committee meeting, about whether or not the $3,000 was separate or if it was in the same pot of money. They're totally separate pots of money. So I think the way that it's written after reviewing it a couple more times is fine. But if there's any changes given that you would like to make, we can make those changes in a red line version. But if not, then I think that this is okay to go to a first reading.
Madam Chair, no changes now that I received that clarification. First reading.
Thank you. Are there any other comments or questions on 0147 compensation? Hearing none, I believe the committee recommendation was to move this to a first read. So unless there are any objections, I see 0147 moving to first read in our next committee meeting. Okay, so that will be joining, I've already lost it, 10651 in our next meeting. Okay, moving right along. We now are at 5120, assignment within district. The current version of this policy is what is provided here. This is the version that was changed during the emergency meeting, but this was brought to committee because of dissatisfaction with the current version. Last meeting, we were offered a proposed version and it was discussed. I know I had some pretty strong opinions on elements that were important to me, and so I have some drafts here of what I would propose as a compromise, possibly, to consider. In my version, I tried to highlight, there should have been a bunch. I tried to highlight where the differences and similarities are from this version, and if you recall, in our last legal policy committee, we kind of went through the last 6 versions that our district has gone through. So I highlighted annually. That was a change that was recommended this last week. I put back the every 4 years because that was in the original version, and then the largest change is just it's just that highlighted rectangle part, trying to add specificity to what appeared to be the problematic area that caused some delay within our process to redistrict. So I tried to find some information. I also highlighted here first, that was a recommendation last meeting from Member Sykes, the first public notice. I tried to compile all of the notes so far and throw it into one paragraph, but I am open to discussion, which is why this is in the discussion portion. Or if we would like time to digest and bring another proposal to the next meeting for discussion, that is also something I am open to hear, but I wanted to try. Oh, also at the end of this, to save paper, I actually wrote to save paper. I wrote a draft statement for public comment that we'll discuss later, but that is completely separate from this. I just wanted to save paper, which then ironically, this is stapled to a blank sheet of paper.
Madam Chair, I would like the opportunity to kind of read over this and to kind of give you my comments after I've been able to do that. And also I would like to hear some comments from the administration. So I don't know if they are prepared today to comment or not, but I'm not.
Yeah, given the circumstances today and all the prep work going into our Finance Committee meeting, I would like to table this and review the matter and come back and have a good discussion at the next meeting.
Well, not table this. You don't want to table it.
Well, we don't want to table it, right?
We want to just leave it in the in the discussion area. Yes.
All right, thank you both. And 5120 is slated in the next round to be the first item for discussion in our next meeting.
Madam Chair, so the board writes policy, but administration implements policy. And so the at least every 4 years, really that doesn't need to be in there because every year we should be looking at that. That's something that we should be looking at every year. So if we only did this every 4 years, then that means what happens in the years when things are happening because you're not reviewing it. This is something that we should be looking at every year. We should be looking at our attendance zones, looking at our schools, looking at our capacity within schools. So that's the reason that was taken out of there, because that's something that we should just be doing automatically every year anyway. I don't know what the rest of this says, but I know when it comes to that piece, and we did agree with the annual piece, but the rest of this, we'll talk and let Mr. Devenbow share. But the at least every 4 years, I think that should be eliminated because that's something that we do every year anyway. So it's not something that we only do at a on a cycle. Like we have to look at this every year, so.
Thank you, Dr. Robinson. Yes, I believe in the last version it said periodically, so I just wanted something specific in there. But if you would prefer annually over every 4 years, I think that's even more specific. And so I would appreciate that, and any more comments in our next committee discussion. All right. Moving right along, we now are at section 3.03, discussion of policy 0131, legislative. There are two options provided, and I believe we might be ready to select one, possibly to move forward for a first read at our next meeting. Would you like to? Thanks.
So just to explain the two options a little bit, the one that starts with any, that has a little bit smaller font, is pretty verbatim to what Dr. Molinar proposed in the last meeting, whereas the other policy is just, it's more or less saying the same thing with different language proposed by council.
Yeah, I was.
Could you read the language? I don't know where you're reading from.
It's the highlighted language in both parts of the policy. So in Dr. Molnar's version, it says any declaration of an emergency necessitating the adoption or amendment of a bylaw or policy must be sanctioned by an affirmative vote by no less than 6 members of the board prior to a vote on such a bylaw or policy. Council's version is prior to amending or adopting a bylaw or policy under emergency, the board shall declare that an emergency exists by an affirmative vote of 6 members of the board.
To me, it sounds like less words to say the same thing, which I thoroughly appreciate.
Yeah. So in order to declare an emergency, we need 6 votes.
That's correct.
Was this the rule before? What has changed?
So, you go ahead.
Thank you, Madam Chair. As I understand it, Member Sykes, it was not prior to, but as a result of the situation we found ourselves in, this was a recommendation that was given, and by situation, when it was declared an emergency or not, and Member Molnar had those questions, I think it was introduced with the 6, because I just didn't understand why it wouldn't just be a majority and it had to be like a super, like 6. What was the goal for 6 instead of just the majority of the board?
Yeah, so before, the policy did not have this statement at all. The highlighted statement was completely absent. It just ended with district. So because of that, there was the opportunity for the district to make a policy in an emergency, and this is what brought us to the special committee meeting. And so what this does is it requires that prior to doing this, the board actually decides that it's an emergency.
So normally, I think we probably go with 3/4, which is actually 5 instead of 6.
Go ahead.
That's just my thought. But I mean, I like the thought that yes, we need a number as opposed to deciding how do we declare an emergency, whether we're using particular incidents that have to take place, using a number instead of if it's COVID or if it's a flood or something like that. But I do think normally, we go 3/4.
Real quick, Haley, if I understand correctly, I think the change, so to amend a bylaw is 6 currently, correct? That is currently on the books?
Yeah, it's actually the next sentence. So bylaws shall be adopted, amended, repealed by an affirmative vote of 6.
So this is saying if we have a bylaw or policy that's under an emergency scenario, we're going to need 6 votes. That's all it's.
So to clarify, like some history here too, I think that this will help clear things up a little bit. The resolution that was passed had a measure declaring the event as an emergency, but what Dr. Molnar is proposing is that there's a vote that takes place beforehand that's not a part of that resolution. So I don't know if that helps
I think that helps.
or hurts, but does that?
Yes, I think it was in the resolution that it was declared an emergency, but the question was who declared it an emergency and how was it declared an emergency? So this explains how it's declared an emergency.
Well, it's understood that if the legislative body votes to declare an emergency, then it's an emergency. That's how emergency is declared, by the vote of the legislative body. So what we're talking about now is how many legislators should declare that it's an emergency. Because, I mean, that's the only group that can declare an emergency in this situation is the members of the board. So
Right.
that's who declares an emergency.
So are you saying your preference will be 5 instead of 6?
No, I want to be consistent with what we've done in the past. And I'm just saying, usually it's 3/4 of the vote, which would be 5. But in this case, you were saying 6. And is my math correct? 3/4 for 5. So I don't know. I would like to hear the other board member, Vice Chair. What do you think?
I was fine with, like I said, the last meeting, just with the majority vote. I'm not married either way. We could say 6. For me, you could say 6 since the amend the bylaws and things is 6 if for continuity, if that's what you're saying. But my only point of questioning was why does it have to be 6 and not just normally like a majority of the board? So, but it's nothing that we need to go back and forth about because 3/4 is fine of the board, which traditionally would be done, or 6. You see, so.
Well,
for
I
me,
can understand why we want, if it's an emergency, why we need a little more than just a simple majority, because it is an emergency. It's just we have such a small number, 7, so that's only one person would not have to agree in order for it to be an emergency. Declaring an emergency is a very serious thing. It is a very serious thing. So we do need more than a simple majority. The question is, do we need 5 or 6? But as the attorney pointed out, that right now, in order for us to change our bylaws, we need 6. So,
My one concern here that I have to throw out is,
Okay.
when you talk about true emergencies, it just hit me. I mean, what if there's a true emergency and we don't have 7 board members? What if 2 were deceased from the emergency? I just want to be careful on that. It just struck me that there could be something where we don't have 7.
block us in.
I think that would be a point where we can suspend it.
You just suspend the rules.
Right, and then go with, because I'm so happy that I know about that, we could
Yeah,
just
we could.
suspend now
Yeah.
instead of canceling a policy,
Yeah.
so, but.
3/4 is 5.
Yeah.
3/4 is 5.
Maybe we should do 5. I don't know. I'm
thinking
worried
5
about.
because the reason why I think 5 is because we only have 7. We only have 7 board
only have
members.
7.
If someone is out or in this someone is ill, and then you have one person that abstained, then one person could stop the vote from being carried. You see?
Yeah, exactly.
One person. So that's why I think 5 would be, personally, the 3/4, which is 5, for me, I think I would be more comfortable with 5 for that very fact, because then one person could stop a whole vote. And so just for the democratic purposes, I wouldn't want one person to be able to stop a whole vote.
I have a question. So the next sentence, the bylaws shall be adopted, amended, repealed, or suspended by an affirmative vote of 6 members. Would that number also change, or is that number consistent anywhere else? And if you need 6 anyway for that, does that?
Yeah, good question.
It's a very good.
Yeah. Yeah, that's why the 6 is consistent, but it's more than 3/4.
I would have to check to be sure, but Dr. Robinson just pointed out to me that it could be state law in that
3/4?
second paragraph here at the 3/4. Yeah, so
Yeah.
that would be something that we would have to check on before, making any kind of change.
If not,
The norm is 3/4.
yeah, if not, then I would recommend that it would be the 3/4, which would be 5, and not a 6. So,
And would that be for bylaws also, or just the emergency piece?
no, the emergency
Emergency.
piece. The bylaws has to be 4.
No, the bylaws
bylaws.
is 6.
I'm sorry, the policy is
Yeah,
4.
right. Policy's
The bylaw, I'm saying, if it's not state law, but I can't remember, so much is going on, I can't remember, but I think that state law says the 3/4, if I'm not
Yes,
mistaken.
3/4 is
That
the
would be the 5.
norm.
Yeah. But we can check tomorrow.
We can check.
Yeah,
Okay.
but the 5 would be better than the 6.
Yeah, but I think it's good language to include. Yeah.
Okay.
Whether
And
it's
then-
5 or 6.
Thanks. So from what I'm hearing is we will bring back to discussion in our next meeting the version, yes, this version of it. But the legal team will find out what, if any state recommendations there are between 6 and 3/4.
3/4.
Any other discussion on 0131 legislative? Okay, moving right along, we are now at 3.04 social media. In our last meeting, we got a presentation on the social media policies, and we discussed receiving copies of social media policies from other districts for the board to compare from. Within the next,
Yeah.
yes.
I don't have any other policies. I've looked around, and, some cities have it. Some school districts have various notions, so it's very hard to jump in. They're all different. Even Neola presents a paragraph that states that employees may not use their personal, web or personal sites where they offend and do some things. So I looked at it, and I don't know if it's going to be very helpful for us because everybody's putting their own turn on it, and none of them are thorough. That's what worries me in the First Amendment arena is none of them are a real good guideline for us. So I just don't think that's a real good way for us to copy, maybe someone else's look at it. I mean, we do have Neola that I think was presented, correct me if I'm wrong, Heidi, did we last time?
Last time there was a large document showing all of our prior versions and Neola's template.
Do you happen to?
That was 5120, I'm sorry, that was a different policy.
Because when I
No,
looked at
last time I forgot the Exhibit A. The Exhibit A is down here.
Madam Chair, did you say last time when you presented this, the first time you presented this, that you got quite a bit of this from the city of Akron?
yes,
Yeah.
This here was prepared by a First Amendment expert.
Okay. So I suspect that they probably looked at a number of different social media policies at the time.
Exactly. And that's why I say when I took on the endeavor of poking around, there are a few, but they're just not, in my opinion, thorough enough. It covers the general premise that, thou shalt not use your personal device to somehow bring disrepute to the district. That's what a lot of the things are stating. And I think this one here just puts us in a little bit better light because, number one, it puts employees on, well, first, it puts our Director of Communications on notice that he needs to go ahead and have a clearinghouse for all social media sites, so you don't have some renegade sites occurring out there that would cause us liability. Two, it puts the employees on notice of what conduct is prohibited using APS district, software and going on district computers. And then it provides notice to employees who are holding themselves out as an employee, maybe on their own personal Facebook page, but they're still holding themselves out by saying, I work for APS, and then they engage in some bad conduct on Facebook. That's regulated. So I think this does a better job of notice in those three areas than I've seen out of any other procedures, including Neola's.
So, I do appreciate the thought that went into it and how long it is, and the fact that it covers multiple areas. I like the idea that we need someone who's monitoring the APS sites, not using personal logins to manage a district site. I think that's something that is probably overdue, but I am a little need more clarification. And as I mentioned before, when you said thou shalt not use your personal device to cause problems with the district, so some clarification or examples on that. I did receive an email as I forwarded to you. I did receive an email, and I thought, oh, this might be a really interesting test case. The email was actually sent to all board members, and it was about somebody saying somebody else did something else online. And I thought, would this be covered under the social media policy? So then I emailed and asked you, would this be covered under the social media policy? And then I thought, would it be interesting to see before and after the social media policy how this situation is affected by our policy or lack of policy? And so instead of trying to email back and forth, which is not transparent, I thought I would bring it up here at the committee meeting and ask the committee, is there a way, or what might be the best way to hear if there is interest in that type of example?
Madam Chair, and board members, I would encourage you to move the policy along because, again, on the operations side, we deal with employees and things that they're doing. We should have had a social media policy probably a long time ago that regulates what people can and cannot do. If you work for an entity, then it's just not okay for you to get out on social media and blast, because when it happens, it's representing our kids. And so I don't think that we should have to manage, without a policy around the behaviors of people and what they think they should and should not be able to do. There does just come a time when you have to regulate that. But without a policy, then it makes it difficult for us. And then, of course, that type of behavior, whether it's student or employee, comes into the school, comes into the system, and then we have to manage something that we really can't control because we don't have a policy.
Thank you, Madam. For clarity, because we're with the policy, were you saying an example of something that would be a violation of this policy that currently happened? Not that we're not moving forward with the policy, but so that we would have some context of examples. Am I understanding that correctly?
What I'm saying is, so rarely do we have a scenario to test against a policy. And I think one of our at least from what I heard, one of the struggles with policy 5120 is the policy was written and had not been used since it was written. And so one of the reasons why we are amending it twice is because we are trying to write a policy for an ideal, but every time we try to use it, there's some sort of conflict. So what I was saying is, in real time, recently, in the past month, the board members have been we were all sent the same email from a community member about something that was related to social media, and I thought this might be a good situation before the policy is official to see if there's how the policy would work in a situation like this, so that way we might be able to adjust it before we'd have to bring it back and readjust it after it's already been used.
But it's one for a first read, right? Or is this, we're just voting on this? I thought this is for Carla's mindset. I'm putting things over here that were for a read to move forward for either first or second read.
We haven't gotten to that point yet. It's in discussion, and after this, we'll decide if it's for a first read.
Okay.
Well, and I'll say this, as far as a policy like this will probably come back in the future, because anytime you're dealing with the First Amendment, the district courts are consistently and constantly issuing rulings on the First Amendment. That it is the #1 First Amendment for a reason, and federal courts and the Supreme Court hears First Amendment cases. So I think on something like this, it would come back over the years, just like many of our Neola updates, because some of those dealing with particularly the First Amendment may come back. What I've tried to do here is borrow this that was already done based on the case law, that as of today, this is good and valid and constitutional.
So, Dr. Molinar, were you saying that the person sent us something and they were complaining that the person, what were they complaining about? Were they complaining that an employee had misused social media?
So in the email that we were sent, they were saying that a person was acting inappropriate, or not acting inappropriately. A person was acting. I don't want to misrepresent the entire thing. In the email, the person was acting in a way that we would not allow an employee to speak as an employee, but they were acting that way on social media, on their private social media account. And so, but they are an employee of the district. Okay. So how would their actions outside of their time be related to this policy?
In being very generic, I agree, will be very generic, but for example, prohibited conduct under Section 5, page 3, it is prohibited. Employees are prohibited from illegal discrimination on the basis of age, race, color, creed, religion, national origin, ancestry, disability, marital status, familial status, sex, gender, identity, or expression, sexual orientation, military status, or any other class that's prohibited by state or federal law. You can't do that at work or in their personal use in connection with any reference to the individual's employment with the district. So that's a key phrase that would apply without going further and identifying our email. If somebody is putting out emails that is, it's sexual discrimination or discrimination based on race, and you have an individual in their bio that says, I'm APS, truck driver.
Okay, yeah.
You identified and held yourself out in the social media world. So, and that's where I think this is needed. I just prefer, I know you said it's longer. I'm looking at trying to find for you right now the language. I'm not holding anyone else in disrepute. I mean, everyone's trying to do everything they can across the state of Ohio and the country. But it was a very general statement that would make me worried on what I was reading to discipline someone, because it just simply said you bring them into disrepute. I just think under the First Amendment we need to provide greater notice to discipline somebody. That's why it's a little more lengthy.
Yeah, and I think, not to keep harping on that same email, so to give a different context or example, I read, because I'm trying to learn about policies before we push them through, but there was a teacher in another state, not our district, a whole nother state, and that teacher had like an OnlyFans account, and so that teacher lost their job as a teacher because they were doing that in their personal time. Yeah.
I think some of these things, and for clarity purposes, some things are contractual when you sign up for your job of what is deemed appropriate, what's inappropriate, and then policies like this. So I don't know, like necessarily without getting too much into the weeds of this, because there's certain things that is deemed appropriate for an employee of the district based off of whatever your contract does and the policies just in general of like non-hating, non-discriminative, as our council has shared with us. So I think even with all that understanding that this policy still could go through without us, and we can still discuss like almost like a case study. We still can discuss scenarios, but stuff is forever changing, so we're always going to, have things. So just personally, I think that even with discussing this later or, as a board, that this still can move forward as is written, in my opinion, even without doing, like we can have, like how we're having this discussion now where people can read in their own times the comparison, and even if you look through to put some suggestions to legal, I don't see why that would hold this moving forward.
I located it. So real quick, it states, employees' use of personal communication devices at work to access social media for personal use, and employees are prohibited from posting or engaging in communication that violates state or federal law, board policies, or administrative procedures. I mean, that's pretty broad. So what ours does is really narrows down and tells the employees and any of us what we can and can't do at work and on our personal devices if we hold ourselves out. So, if somebody's anonymous, you can't do anything with it because they're anonymous. But with all that said, I found that portion of it that I think is very general, and not throwing shade to this particular one, but I just think ours is identified as prohibited conduct that will allow us, in the unfortunate situation, someone posts something regrettably, that we can discipline them, and it's clear, prohibited conduct.
And so, I guess for confirmation, if that other teacher with that OnlyFans account had worked in our district under this policy, would they have received discipline?
Yes.
Yes.
I would say under that. I read that story. And, it gets a little touchy, you have to figure out, make sure they are holding themselves out. But you also don't forget, as teachers, licensed, there are other avenues for teachers. So not just the social media, this would be one, but then you have other, issues that you could address with a teacher. They're in a little bit of a special class. Because again, this doesn't apply just to teachers. This is across the board for all employees.
All right.
Because the more you start talking, then I get scared that my people's First Amendment rights being infringed upon, what they're doing in their personal homes. But if it's unbecoming behavior of an employee, like I work for, like at my job, it's certain things, but I sign contractually things that says this is my lifestyle, this is what aligns with, and so I understand that anything contradicting that would be an issue, and so I just the last part when you start talking, like it just I didn't know because it sounded like I just was uncomfortable because then I'm like, wait a minute, it's one thing something outlandish, which is very clear, discriminatory, like a ironclad statement, but then in your personal time.
Well, it's not just in your personal time, it's in your personal time and you're holding yourself out as an APS employee.
But and that's where I think it's great for me, because if say Member Sykes just an absent, and she's a parent of the district, and she knows who I am. And even if does that still qualify? Even if I don't have that I'm Carla Jackson, English teacher at a public school, but Mrs. Sykes knows I'm her child's English teacher, would that still?
It
because
can.
It's not me putting in my bio, but that could still be a problem.
It can if you're recognized as an employee.
that's what I'm saying,
If you're a
if you're
representative of APS, it could.
Okay.
But keep in mind, these exceptions, I mean, they're not protected by the First Amendment. You know, it's obscene.
Oh, yeah.
You know, legal activity, illegal discrimination, threatening, intimidating, could be in certain circumstances, inciting violence is not, defamation is not. So these are not protected by the First Amendment, the majority of these. The other ones are dealing with confidential information, you know, something that may be covered by FERPA, and you're putting it out there. So I wouldn't be too uneasy. I mean, we're not going on a mission to find everything. It's just certain things are said on there that are brought to our attention that are bad and they need corrected, and it's discriminatory or it's obscene. Then you have to take action. And I think this allows us to do that in those rare circumstances.
Editorials in papers talking about students.
Well,
Or something
in
like
a
that.
paper's completely different.
No, I mean, not the official, I'm talking about when people write in as I'm a teacher, and if someone identified, that would be something like that.
I don't think they would be, I don't think they'd be covering the prohibited conduct areas, though.
Okay.
You know what I mean? Writing into the paper and engaged in bad conduct probably wouldn't happen.
Something was shared with this board about some negative comments someone wrote, talking about a student in the district, but it was anonymous. Okay, I think I don't need to belabor it.
Yeah. Do you have something? I completely agree. Confidential, proprietary, all of those things are incredibly important, especially right now. I know some of the talks we're giving when it's related to AI, ChatGPT, things like that. People are sharing confidential information and they don't even realize that they're sharing confidential information. I get that, and I understand any type of breaking the law and things that are illegal. You know, we don't want to encourage anyone to break the law. I am concerned. Because of this OnlyFans situation, I am concerned about the values judgment being placed on that. It is not against the law what that person did. It was just against the values. And as a public school, I don't know. Obviously, that was not happening in the school. It was happening outside of the school. But the values are placed on that person. And I wonder if a compromise to that might be in the gray area, Ms. Jackson, that you were talking about, of whether or not you are identified and you are identifying and you are labeling yourself as a district employee, or if you are simply recognized as one. Is there a way in here that we could say the person is proclaiming themselves a district employee or representative?
I mean, there's a famous case out of San Diego, and it was a police officer, and the police officer did a video, and he didn't identify himself as a police officer, didn't do anything else, but he had on, as part of his pornographic stunt, just a shirt of his uniform shirt, and that was enough. He was holding himself out as a member of the San Diego Police Department while he was engaged in this act. It was violative of their rules, you know, and that's sort of the game that occurs. I wouldn't think. I mean, you have to hold yourself out as an APS employee to fall under this. You know, let's not forget we're battling here, but should you discipline anyone, you're facing arbitration before a neutral. So you have to have sufficient evidence to meet the fact that this person was holding themselves out. And I can see a OnlyFans where the person wouldn't fall under this, and I could see an OnlyFans where the person would. It just depends on what type of conduct that person's putting out there to see if they're holding themselves out as, you know, by the employer. If you wear a mask, no problem. You know, I mean, you can't, we're not going to know who you are, right? So that's why I say it's a very difficult area. And I can only say I think this is probably the best way to try to regulate in this arena. And it's for some pretty significant conduct, particularly in the field of schools. You know.
Okay, so I have no objections to this language.
So is it the will of the committee to move this to a first read in the next meeting?
That would be my recommendation, Madam Chair.
All right, 7544 is moving to a first read in our next meeting. 652, we can do this. We can do this. The next one is 0155 committees. Language is provided here for committees. This is about having our agenda up whenever possible 7 days before the committee meeting to provide adequate notice to our community.
I have no objections to this language, Madam Chair.
Okay, so is it the will of the committee to move the committees to a first read? Okay, wonderful. Thank you. Next one is 2340 field trips. I think there is an administrative representative to present to us on field trips.
Mr. Duffbaugh, you weren't planning on
No.
I can go
You
ahead
could
then.
go ahead.
Yeah, I don't think that there's anyone, unless, Dr. Robinson, did you, well, let's start here. So,
Let me say this really quick.
Sure.
I worked hand in hand with Diana Feidel on this matter. It's an important matter that she's helped out and we discovered. So Diana put this together for us.
thank you, Mr. Duffbaugh. So this, the addition of this policy is essentially to make sure that there's criminal background checks for chaperones for field trips, same kind of background checks that are performed for every other district employee, so those revised code sections that you see referenced there are both reference background checks in public schools and disqualifying offenses. So if you disqualify for an offense, if you're a normal employee, you would also disqualify as a chaperone.
Yeah, I have no objection to this language. I'm just shocked we didn't already have it in our policy. Wow.
Good.
Any other questions or comments? Are we ready to move this to a first read in the next meeting?
So move.
Okay. 2340 field trips in our next meeting. And now we are at 3.07, discussion of Neola updates and administrative priorities.
Okay.
So I'll speak to this. So Neola, for everyone who doesn't know, and I know that sometimes we like to just remind the public of what Neola does, is that they are a company that the district works with to develop and update the bylaws, policies, and guidelines, et cetera, of the district. We are requesting a separate process. The administration is requesting a separate process as a part of the agenda to push through the mandatory Neola updates. And we would have either a separate agenda or a heading specifically for the mandatory Neola updates in order to get caught up on those updates as one of the priorities for the administration.
Madam Chair, I would just ask, what do you mean a separate agenda? How would that work?
So I guess a separate agenda would probably be the wrong thing to say, but it would just be a separate section. So instead of going to new business, roundtable, and through the process that we have right now, because there are so many updates that we need to get to, and in order to get them done a bit more quickly, we would have a separate section where we would bring the red lines in immediately with a staff representative, a district representative, for someone who could speak to the changes within the policy. And then at that point, we could either be a first reading or there could be changes suggested, but it's just the administration's will to get those updates done.
I have a question. Are there any specific policies that are being brought to our committee today?
Not today.
Because is the plan to bring them all in bulk or individually, or?
I can't speak to that at this time. I'm not sure exactly.
Go ahead.
As I was, and please, this is just for clarification, because as I was understanding, I thought, are you saying that these are outstanding policies that are mandated that need to be approved? And so when I hear the language outstanding, to the point, when Member Molnar just made her statement, it makes me think there was something that was brought before us that was not addressed, and then Molnar asked her question, like, when are we going to see these? So when you say outstanding, it makes me believe that we were apprised of something and we didn't handle business. So I just want clarity on that.
No, and you may know more than me on this, but from what I've recognized and Heidi has shared with me from Neola, if there's a change in a statute, if there's a change in federal law, they'll send an updated, and they'll call it a mandatory, if I believe, and they'll say this is a mandatory change because either federal law or state law requires it, and it's not it's not cumbersome. Some of the changes are pretty minor. I don't know if we could bring them all because I think we'd have to internally look at them as well to make sure, it's in order.
Yeah, that's all accurate. And you're totally right that some of them are small changes and there's not really much to discuss. Hence, we would have a staff member be able to look at the red line, sign off on it, and it would just be a quicker process than what we're used to doing at this point.
As I look at the pile of policies that we discussed today in less than an hour, we have 1, 2, 3, 4, 5, 6. We have 6 policies going to a first read already in our next meeting. And I think some of these were quick. Some of these were quick because they were, a single line that was in here. So I really don't understand why the Neola policies would need to follow a different procedure than any other policy that we are considering. If we have ones that the district is already going to review and the district is going to present us, that's exactly why this agenda was created, so we could have new business, it could go to discussion, and then the committee would have a chance to discuss it. As I recall, before this agenda, things would go directly to a first read, which means administration has had time to look at it and the board and the committee had not. And so the thought process was that if it was presented in discussion, the board could receive it in discussion, and then when it's a first read, we've already seen it and we've had time to look at it and consider it. And so as far as the timeliness of it, I appreciate the need for things to go in a timely fashion, and that's why we are moving 6 policies to a first read in our next meeting. We are being incredibly productive as a committee, in my opinion, and if it was that urgent, then I am disappointed that we don't know, it hasn't been brought to new business. We haven't even tried to put any of the Neola policies through this process. None of them have been brought to new business.
So, Madam Chair, members of the board, well, she is a doctor. Attorney Feidel said that she has spoken with you, Dr. Molinar, in reference to the process that we're doing with certain policies. And these Neola policies do need to be done in a little bit more of a timelier fashion, because the agenda that we have now, which is different from what we were doing prior to, brings policies to a deliberation and discussion with what do you call it, round table or something. You're not gonna, at least since I've been here, we've not brought any policies from that we've gotten and they went straight to the board. I mean, it's always come, but I haven't been here a year, that it's always kind of come through. But we are a little bit behind when it comes to these Neola updates, and we do have to stay within the time as close to it as possible to what the state is when they send these Neola updates. We need to be able to get those things through, make the updates and the changes of those policies. So it would still come here, but what we're asking is if we could move those updates that come through a little bit faster than, like, for example, the social media policy. I think we spent about 2 months, 2 meetings, well, that would be like 2 months, on that, whereas with some of these Neola updates, they're just updates. Like, they don't necessarily really need a whole lot of discussion, even though it could and still should come through this committee. But if we could move those updates through, process those a little bit faster than them having to go through roundtables and those types of things, because they don't necessarily, it's not like we can, in some cases, we can't really make there's nothing for us to discuss. If it's an update based on what the state is saying, then it's not really a debatable issue. It's that this is the update, we got to move it forward. Yes, it should still come here, but it needs to come here and then go straight.
I have a point of clarification in regards to the social media policy. Yes, the social media policy took 2 months. The social media policy was not a Neola update. It was a new policy.
I was using that as an example.
I know. So I'm clarifying that it is a new policy created based on something our district has never had before. So it did require much more consideration than a Neola update. No Neola updates have been presented to this committee this year. None. The policies that are going through quickly are going through quickly. There are policies going through quickly. This committee has been incredibly productive, and it sounds like the part that we are being requested to skip is the discussion. So let me ask and clarify, is the goal to not discuss Neola updates? Because I feel like the reason Neola updates exist is because case law has occurred, and in situations in districts have occurred that have required recommendations to change across the state. And I feel like possibly it might be good for us to be aware of some of those things.
So I'm glad that you brought that point up, because I can't speak for previous administrations, but this administration, even before I became the superintendent, I do not have an issue with public stuff going with the community, because those are the people that we work for. So certainly we want them involved and want to hear their voice. I have no problems with the stuff coming to the committee. That's why we have these committees, so it can come through here. What I'm saying is, in speaking with the attorney, that some of these updated things, and we have had Neola updates when I first got here. I mean, again, I've not even been here a year. But all I'm saying is that when those updates come, if we can have them either in a separate section of, because Dr. Feidel says she has already spoken with you, but if we could have that in a separate section and get through that and let us move those, because those are just updates. Yeah, it may warrant some discussion, and certainly you need to have that if the committee feels that, and the board feels that it needs to have that. All I'm saying is that there are some of those things we got to move a little bit faster on because we do have timelines that we kind of have to meet, and some of it we're not meeting.
So I would like to propose, since if we aren't meeting deadlines, that hurts me because they've never been brought to this committee. And
Well,
so if we
Ms.
aren't meeting those deadlines, that's a shame that we haven't had the opportunity to make these policies right. And so it is my request that some of these policies be brought to new business. Give them a chance to be brought to and through this committee. And if, for some reason, we are on an expeditious timeline, perhaps we can do something like suspend the rules on a situational basis. But none of them have been brought to us.
I don't think, well, that's inaccurate because you weren't the chair prior to being the chair now, and those things were brought.
I've been chair.
Well, then they were brought between August and December. We've had Neola updates that have been brought. And in speaking with Dr. Feidel, Attorney Feidel, what she has asked is that, can we get these updates done in a more timelier manner so that stuff can move forward? Like a social media policy is something that has never been brought to the district, or maybe it's a policy that we're spending some time massaging and talking about. That's a little different. That would be in another maybe section of your agenda. All I can do as the superintendent is bring it to your attention as the committee and ask that we try to do more around compliance of these Neola updates, because it is holding us from getting some things done when we have to go through. Again, I'm not saying there shouldn't be any discussion. I'm absolutely all for that. All I'm asking is that it not have to go through a round table and then we got to come back, because now we're 2 months, possibly 3 months behind on getting these done. I'm not saying for all the other policies that it can't go through the process that you've established, but I am asking when these Neola updates come up, if we can please bring it here, have discussion around it, and then move it to the board for approval, while the other policies that we need to spend a little bit more time on can go through whatever process that you have established. I think a roundtable or something, those might need to take a little bit longer, especially if it's a brand new policy. I'm just referring to the updates. But again, as the superintendent, all I can do is bring it to you and ask, because our attorney has asked this of me, when it comes to the Neola updates. So it's still going to come through this committee. And since I've been here, nothing has just come in and gone straight to the board. We have brought it to the committee. That's what our committees are for. And all I'm asking is that when we have these updates, if we can work collaboratively with our attorney and get these things done, rather than them having to go through deliberation and roundtable, something, a longer, different policy or something we're trying to do, other things could go through that process. I'm not asking you to eliminate your process. I'm just asking if these Neola updates, if we could maybe put those at the first section of the agenda, and if we could move those along a little bit faster than what we've been doing. That's all I'm asking.
Madam Chair, I think that what you're asking is reasonable, but I just think that the chair is saying that as far as she knows, and I'm new to this process too, as far as she knows, that there's no Neola item have come before that has been delayed. And that if, in fact, you have Neola items, I think if you bring it before the committee, if you say this is a Neola item and we need this to go through the committee, I would not object to that and moving it straight on to the board. And I don't think I heard the chair object to that.
Yeah, I just don't think having a separate item
No, I don't
in the
either.
agenda is necessary.
Yeah, I agree. We don't need a separate item on the agenda. I mean, it's the agenda. It's the agenda. If it's a Neola item, it's on the agenda. And if you say that we need to fast track this, then we'll fast track it.
Okay. Again, as a superintendent, all I could do is bring it to you.
And let me just say, Madam Chair, I appreciate that. So would you give us an opportunity to do that? So bring the items before the committee and say this is a Neola item and that it needs to be fast-tracked, and just at least give the chair the opportunity to do that.
Yes, ma'am, Ms. Sykes.
That's all,
But
that's all.
the attorney has spoken with Dr. Molinar. So that's why she came to me and asked me if we could move that along, because the attorney was the one that asked about
Is that a particular item?
4 hours ago, I was told this discussion would occur tonight. That is not the same thing.
But is there a particular item that we're talking about?
So I've had 2 meetings with Dr. Feidel regarding our processes. And she has had discussion with, because I'm not a part of the committee and the planning and all of that. I'm not
Well,
on.
clearly I'm not either, because I haven't had a discussion like that.
So that's why I was mentioning it. If we could, when it comes in the Neola updates, if we could do that part maybe at the beginning, get those out of the way and move them along, whereas other things may take a little bit longer, and it will go to the discussion or the round table, and then it could be, another month before that's settled, because you're deliberating or discussing it and having discussion around it. Whereas some of the Neola updates, those are just what they are, updates. It's not really for us to debate it, or, you could still discuss it, which I said, still bring it so that because you have new people, even some of the veteran board members might not even know about some of these policies, so you would have some form of discussion around it. I'm just asking if we could move those things along a little bit quicker.
Well, if they're never brought to the committee, then we can never move them anywhere. So I think the first step is to bring them to the committee. That's the first step. Go ahead.
And I would just say, as a vice chair, I have no problem in fast-tracking Neola items, none whatsoever.
Additionally, can these items be sent in advance to be perused and looked over before the actual meeting? So as we move them up in the agenda, and pass them forward, we don't even have to belabor this conversation if the board is privy to seeing the updates that are mandatory within a timeline, to just move those forward, because to Dr. Robinson's point, it's clearly it's some type of disconnect here, because Member Molnar is saying she has not seen these things, and I know in the meeting, leadership was in the meeting with the attorneys where they're saying that possibly the agenda is not effective. The new agenda is not effective, and now Member Molnar is saying she's never seen these things. So just for the sake of taking care of the business of the district, because I know no one around this table, especially I'll speak for myself, I don't want to be seen as incompetent or not taking care of the business and in violation of things moving forward. So
we would never see you as incompetent or not taking.
Thank you, Member Sykes. But you understand, so that we can just move it, as Member Sykes said, so we can just get to the business. It's very, you're not going to have any issue from me either, but I would like to be able to peruse it. If we can get it in advance, then it's your responsibility, because it's coming in advance, to look over it, and then when it comes to this committee, because it needs to come through this committee, we can just move it up on the agenda, go forward, and then the other business, new policies that's coming up, we can roundtable and discuss those at length, but we can get the Neola, the mandated things done. And it just, however we can be is efficient. But to be aware, and if we can get them emailed, then no one can say we didn't see them. We are aware, and then when they're on the agenda, we just take care of the business. If that, Madam Chair.
Yeah, and so as a reminder, transparency is and has been my #1 priority in creating this agenda. And that's one of the reasons why we made this agenda, because it was a board priority, was to be transparent and to be able to offer to the community what the agenda was going to be ahead of time. It would to prevent lots of side conversations, back conversations, quick emergency phone calls and additions and revisions, trying to reduce those things, because things get lost in communication, and it's nice that we have everything recorded and live streamed and presented as a team and as a committee. We are co-constructing this agenda with no surprises or emergencies. So with that, a section that is, possibly 5 minutes or 3 minutes we don't necessarily need, but I find incredibly important, is this policy status review. Because policy status review is a section in every agenda where we can fast forward and just see what the agenda, a reminder of what the agenda is going to be in our next meeting. And so as a review of the things that we have discussed so far today, that we actually have no policies moving forward for a third and final reading, according to my notes, in our next meeting next week. We also don't have any policies heading for a second reading next week, but we have 6 policies headed for a first reading in our next committee meeting. So 10651, 0147, 0131, 7544, 0155, and 234, my bad handwriting, 6 or 0? 2340, field and other district-sponsored trips. Being a great example of a policy moving through this committee, as it will be there for a first read in our next committee meeting. So our agenda for our next committee meeting will be 1, previous meeting summary, meeting minutes, 2, policy readings, and those 6 items. Section 3, roundtable of our next meeting. The only item we have on the agenda for that is 5120. The only item that is lingering in roundtable is 5120. That is to be expected given the circumstances. And so with that, we're at unfinished business. We do not appear to have any unfinished business. Section 6, new business. We were going to have a discussion of levies. The reason we're going to have a discussion on levies is because at Levy University, sponsored by OSBA, they gave us a list of policies to consider if your district is considering a levy, just to make sure we have all of our ducks in a row before we're in a levy. However, it was relayed to me quickly today before the Finance Committee meeting that, let me make sure I have my notes here so I don't have it wrong. But basically, because we have not committed to a levy yet, this is not something that needs to be our concern yet. So we do not need to be looking at levies yet. But if we have a list of the levies from OSBA, we might consider bringing those to the next meeting. So I will ask the committee, because that was brought up in our last committee meeting, do we want to look at the list of levies from OSBA in unfinished business, or just wait until we actually, as it was recommended, decide to go for a levy?
Madam Chair, I would say that let's just wait as recommended.
I'm in complete agreement with waiting. However, can the information be shared so that we may peruse this information in our private time, so we can have a rich discussion in the moment that we meet?
Yes, I think we might need to have to contact OSBA to get the list that they gave us in Levy University. I think we have access to those slides, those of us that went, so we will try to look at those slides. All right. And the last section in our agenda is other policies to discuss. Did anyone bring any policies to the board?
Madam Chair, I would just ask, just for clarification, do we have any Neola or anything to come before the board? All right. Thank you.
Thank you. Yes.
My apologies, Madam Chair, but if I can email you a policy that I'm going to look at, dealing with the attendance policy based off of our student board member who came in a couple weeks ago. I think it would be good for us to revisit that policy as well. I think this may be a state issue, though, as far as credit recovery. That may be something at the state level, which I will look into to see how can we maybe reevaluate those policies. One, the attendance policies for matters of emergency and the student's ability to make up work like over a summer semester and receive something like a withdrawal. Anyway, that's something we can discuss further, but that the policy about attendance and grade changes.
Would you like to just bring that to discussion in the next committee meeting?
Yes, please.
Add that to the, okay, so
Yes,
we'll
thank
add,
you.
I'll just put notes, attendance
Policy,
/
yes,
Jackson.
and credit recovery, grade, like the grade, makeup grade.
Credit recovery, makeup grades, Jackson.
Yeah.
That way
I'll
we
get
know.
the technical language.
That way I
It's
know
better
I'm not
language.
looking anything up.
Yes, thank you.
Okay, and that reminded me, thank you, I actually had possible language to offer the group. Draft statement for public comment. Now that we are having public comment, as we learned earlier this evening, in people possibly interested in signing up during our committee meetings, the statement for public comment that we were using for regular board meetings, as we tried to use in our last committee meeting, did not quite fit, and so there is draft language here to be considered. I believe Member Perry read this statement before the Finance Committee meeting. It's very similar to the other one, and it's not a policy, it's not a bylaw. I don't know if there's anything that we need to do as a committee for this, but if anybody has comments, concerns, objections, edits, I'm all ears. Okay, and with that,
Madam Chair,
yes.
real quick, when you talked about new policies, we will be bringing one that's very important. It's about emergency inhalers to the next meeting. So I just wanted to throw that out. We'll get that done here shortly and circulated to everyone.
Would you like that also in the discussion section?
Well, whatever section it needs to get in to get passed.
Okay.
I want
so,
to be able to implement it at the start of the 24-25 school year.
So
Yes.
in discussion, yeah, that's exactly what we do in this section right here. So can we, are you going to be presenting it? Are you both going to be presenting it?
We'll both present.
Okay. So we'll also add inhalers policy in discussion in our next meeting, and it will be Carter and Diffabaugh. All right. So we now have 3 in discussion and 6 in first read for our next meeting. Yes.
Land this plane. Also, for considerations, I know when we were discussing the public participation policy, that we had stated that we would allow public participation when it was germane to the topic, and I did not see that happen today. Not with when we had the conversation, like if someone wanted to speak on the part about the cuts, that it should have been a point, as I understood when we were drafting the policy, that at that point it should have been given to the audience if they had discussion on that point. And if there were no for that point, we can move over. And I do know, Madam Chair, you said it was at the discretion of the chair, but if we put a policy in place, I just want clarity on that, because
Yeah, I
so
think,
that I'm not.
I agree, and I think there was confusion also in our previous meeting about signups, because we had the paper sign up at the door, but then the paper sign up was brought in, so people coming in through the door couldn't sign up anymore, and then there was a person who signed up online, and the person with the paper sign up didn't know about the people who signed up online. So procedurally, I don't know what the team would like to do to find out how to do that, because I agree, we could do that. We could have done today better, and if today exists again, we should do that better. Team.
Madam Chair. Yeah, just the policy, the point of when does public participation take place. That's logistics, what you were just referencing. I'm referencing the policy when we were working on it to draft it, that we said that public participation will be allowed. When were we going to let them participate? Should it be when it's germane to the topic? So if I'm sitting out there and I want to just talk about strictly about this cuts, I have to wait all the way to the end. And I love how Member Sykes said, for memory part, because at that point when things are fresh, we stop, we handle it and close. That's what I thought we discussed. And I just want to be sure, because I want to be consistent. just that we're doing the same every time. I don't want us to get into gray areas and weeds where we're not being consistent with the participation when we're at our committee meetings or in any event. So that's, I just for that to be brought before this committee.
Yeah, I don't think I was at that particular committee meeting, so I'm not clear on exactly how it's supposed to go. Are we saying that there could be several points during the meeting in which we would entertain questions from the public? Is that what the policy is suggesting?
Yes, and we were present. We said the actual verbiage was that it must, if it's germane to the topic, meaning.
I remember that part.
Yeah, because you were here.
But do we stop at every point along the agenda if there's questions?
For that topic, and that was what was discussed, and that's, as I understood, that if there were questions for this specific item, then the floor would be open for those. If not, then we will move expeditiously onto them. That's how I was understanding it when it was originally discussed and compiled. If I'm in error, that's fine. I just want clarity so that whatever we do, that the committees are consistently doing the same thing, and through every committee that we have a standard operating procedure of how we do public participation when we stop, start.
Right. When you had sent the note earlier, I thought you just meant where are we going to have the public comment? At the beginning of the meeting or the end of the meeting? But you're stating that it could be several times throughout the meeting, depending on what particular agenda item.
Yeah, per topic. Isn't only supposed to be public participation per, like to open it, if you're here just for this item, then you speak on this item, and then they may want to leave, just to be respectful of the time and memory.
Oh, I absolutely feel the memory part, but it seems like.
So that we're clear. If we're not clear, which is why we got a policy, then we need to make it clear, whatever it's going to be. I just don't want us to be in a situation where it seems that we're being inconsistent with how the public participates since we've opened up. Since we've opened up public participation to committee meetings, then it should be a standard operating procedure for every committee meeting, and it should be the same every time. If the clock is going to be up, the clock should be up. Like the consistency of it. If it's 3 minutes, it's 3 minutes. If it's germane to the topic, then it's that. But it must be that every time. Just so that we, do it.
So, like, for example, with today's committee agenda, these roundtable discussions, after every one of these policies, we would, if there was a comment on every single one of these 6, 7 policies, then we would stop every time in between each one.
Or to your earlier logistic question, if they're doing sign up and they looked at the agenda, then it will be listed already on the agenda which part. Now, of course, for people who just show up day of, but for those who are doing in advance or when they're signing up, then we kind of can have some idea if that's what, to make things flow better. But just for some considerations, and, I don't want to, the time is now 7:30, so I want to be respectful to the time, Madam Chair, but I just want to be consistent.
I agree that improvements and inconsistency can be made. I also agree that when people sign up, it would be nice if there was another column for the committee sign-ups for the people to self-identify maybe what their topic is. So that way, when you receive that list of sign-ups, you kind of know, okay, there's 6 topics here, but there's only people here to talk about number 3, something like that, because it felt like, everyone was grouped together. There was one separate person. So I don't know if if procedurally, it would be easier to try to just make a new sign-up form for committees. Is that what we think might be easier? Or how do you think we would best accomplish this? I also want to be cognizant of the time, but I do also feel like we could come up with a plan.
Can I interrupt now? I want to wade into this, I'm sorry, but based on this discussion, maybe we should have a separate mandatory Neola section, because I'm not quite sure where public comment, if it's mandatory and you have to make the change based on state or federal law, maybe we should have a separate section for mandatory Neola, blast through them, And then if you're going to have public comment after each individual policy, it would be, from the non-mandatory down.
I think I would still be willing to hear if there were 10 community members that really wanted to speak on a specific policy. And because what happened several times last year when I was chair of this committee is a policy would come up as a Neola recommended change, but during that Neola change, we would review the rest of the policy and we would see pieces of it and go, actually, can we do this and this? And so some of those policies kind of hung out because of the conversation that came out during that recommended change.
I think we have to split hairs here. My understanding is from Diana, there are mandatory and then there are just, hey, here's some recommended changes. The mandatory are required as a matter of law. And I thought that was the part, if I understood correctly, that we need to bring to the committee and move along, which could come in batches of 10. And I don't want to speak for council, but there could be 10 policies. So maybe.
And Madam Chair, please, let's not go to this discussion again.
Yes.
Please.
Sorry. Thank you. So back to Member Jackson's comment on the signups. I will draft a sign-up table, or would somebody else like to draft a sign-up table for committee meetings? The next committee meeting is an instructional policy committee meeting. Would you like to? Okay, I'll volunteer. And with that, is there anything left to discuss this evening? We stand adjourned 7:34. Thank you.